Hello, hello, hello.
And welcome to the Hildebrand Law Firm topic for today.
I'm Kirsten Hildebrand.
And I'm Matt Kaplan.
And today we are finishing up on what ended up being a little bit of a longer discussion. We keep talking about the things that if your trust doesn't have this, you might really want to consider a redo. And we have covered things like trust protectors, understated age beneficiary trusts, spendthrift provisions, making sure that you name who your beneficiaries are in the trust, disability panels, disability trust, separate share trust. And then now we are going to talk about one final issue, and that is, do you want to allow your trust to be the recipient of IRAs, 401ks, and other qualified assets? So the first question would be, why would you want that? Why would you want an IRA to have the beneficiary not be to your three children, but to be to the trust?
It's a great question. And the reason being is because Kirsten and I just spent about 25 minutes talking about all the wonderful things within the trust that you don't get to utilize if the beneficiary isn't the trust. Let's say one of your kids happens to be disabled at the time you pass away, has spendthrift issues, is under the age of 25. Let's say you want to utilize a trust protector. Well, someone's disabled, something like that. You can't utilize any of those provisions if they are the named beneficiaries. What if you pass away and one of those kids is even under the age of 18 and they're just a named beneficiary, but you say, but I have it as 25 in my trust. Too bad you didn't name the darn trust. You just named the kids, and then the money goes right to the kids.
And sometimes these are our largest assets too, and the ones where we want to make sure that there is protection and that there is oversight and there is a trustee managing that those assets. And so you're absolutely right. If you have somebody who is 18 years old and you pass away and you leave a $800,000 IRA behind, that 18-year-old gets that money immediately. If you name the trust as the beneficiary of that IRA, now the trust, if it has the proper language in it, can accept those assets. And the proper language is really, really important. And in fact, it's several pages that is specific IRS language that talks about the way the tax treatment should go with respect to an IRA. Because, of course, an IRA, generally, the vast majority of the time, is not taxed. And so you don't want to necessarily have the beneficiary be the trust unless you have all of this supportive language in there relative to taxation and making sure that the trust acts as a conduit for the IRA money. And when it's pulled out, it's not taxed at the trust level, but it's taxed at the individual level. Why is that?
Well, because most individuals' tax rate is way lower than what the trust would be, especially, if they're maybe younger kids, even if they're in their prime earning years. I would check with a CPA, depending on the level of the trust. From what I've heard, on average, 35, 40, 45% it could even be, depending on your state. It is a ridiculous tax that you don't want to pay, nor should you. And so having the right conduit language in there will allow you to save so much money on taxes.
That's exactly right. So really, we have run across financial advisors who are so concerned about making sure that there's proper tax language in there that they generally hold that the IRA or the 401k, that the beneficiary should not be the trust. And that is a conservative and well-meaning decision and piece of advice that they may be giving out. However, if you have a well-written trust, it will have that language in there, and it will give you the flexibility to then have the trust named, and certainly run your language by your financial advisor and make sure that it is up to snuff, because it does need to be good language, as I said before.
And a really important thing to consider too, why you would want to do this as opposed to just writing in the kids or whoever else the beneficiaries are, is because these separate share trusts that we talked about in the previous video, they have contingencies in there just in case one of your kids or whoever your beneficiary is were to predecease you. you might not have a contingent beneficiary set up at the beneficiary level. If that's the case, then what happens? Then you need to open up a guardianship on that kid's life, or not a guardianship, a probate on that kid's life
Mm-hmm.
in order to figure out where that person's money is supposed to go. All of a sudden, you made this trust to try to avoid any of this nonsense. You're in the middle of
And
it
it's
because
all
you're not
there.
using it.
That's right. Yes, I think that our advice is always, if you're going to buy a trust, buy a good trust, and if you're going to buy a good trust, use it to its maximum potential. Use it wisely and make sure that everything gets in there so that then everything moves smoothly. So,
Love it.
yes. Well, thank you so much for joining us for this bonus on the items that really should be in your trust. There are a lot more. But at any rate, we are here for your today and your tomorrow, and we will see you next time.